Pleasure. So welcome to everyone. It's a real pleasure to be here and to hear these presentations. Topics are really extremely interesting, and I'm sure it will be a very fruitful afternoon. But as I was saying, I think we don't know each other. And it will be, and I'm sure that many people here don't know who I am. And so I think it would be nice if each of the presenters and myself too would say a couple of words, introducing themselves and saying hello to the audience. So if you all agree with this very short program of mine, I would leave the floor to Chiara Graziani.
Yes. Thank you, Chair, for this presentation, for this introduction. My name is Chiara Graziani, and I am a research fellow at the University of Genova. My field of research is national security, human rights, with a particular focus on counter-terrorism and the measures that are adopted in order to fight terrorism that at the same time have to be balanced with human rights. And my presentation of today will deal with the specific aspect of counterterrorism, which is the use of artificial intelligence in the counterterrorism operation, and even more specifically, the use of facial recognition tools. Thank you.
Thank you. Is your research still going on, or is it, I mean, the topic you are
my research, yes, my research is still going on, because I have just defended my thesis in general with dealing with the relationship between security and human rights and focusing on a very wide scope, but now I am focusing on technology and counterterrorism. And so yes, it is still an ongoing research.
Great, thank you.
Thank you.
And now to Nausica Palazzo. There.
Good afternoon, everyone. Can you hear me?
Yes.
So my name is Nausica Palazzo. I'm a postdoctoral researcher at the University of Trento and Fondazione Bruno Kessler Center for Religious Studies, and adjunct professor at the Bocconi University, but professor a contratto sounds better. And I'm doing research on comparative constitutional law and comparative family law. So I'm currently doing research on the legal recognition of new family forms, but I'm also interested in voting rights, comparative discrimination law. That's it.
Thank you. And Francesca Raimundo? I see her, yes.
Wait.
We don't hear you.
No. Adesso sì. No. Yeah, there's something with your computer now. There's something with the volume of your computer. Maybe you've turned it off, because with Zoom it says that you are unmuted, but maybe your computer is muted. Just see if there's at the bottom. I don't know if you have a PC or you have an Apple or you have a Mac, but you should see at the bottom. You should see on your keyboard. You should have the mute and mute.
We could have before.
No.
Now.
No. No. It's here. Sorry.
Well, meanwhile, let me greet Professor Munateri, who has just joined us.
No, it's you should do it here on the keyboard. Press this.
Oh, nice to meet you.
Well, we'll ask Francesca Raimundo to solve her problem, and then I think that's better. I just want to say that to Professor Kay, but maybe you already know PG Monateri, who is the past president of the Italian Association of Comparative Law. He's somewhere here on the screen.
Yeah. Well, here I am. Well, is there anything I have to do? No, just to have you.
Just to make people meet, you know, sort of get people
Okay.
to measure.
So it's a pleasure to meet you all, even in this form.
A pleasure for us to see you here.
Hi.
Bye, Maria Donata.
So maybe Francesca is ready now.
No, she is
she's not ready. So, what do you think we might do?
We start.
Unless,
we start, and she can, and she when it's her turn, she'll present herself.
Yes, I think it's a good idea. So let's start. I'm not going. Oh no! First, I wanted to introduce myself because Vincenzo, Pigi, Giuseppe Franco, Antonello all know me very well, but maybe the younger generation don't know me. I was saying before that I am as old as I am so old that I met Gino Gorla in the flesh, in person, many years ago. But in any case, well, I am rather involved in comparative family law since a few years. I'm a member of the Executive Council of the International Society of Family Law. And once I also was the secretary, the general secretary of the Italian Society of the IDC, of the Italian Society for Comparative Law. And I'm still proud of that, that period. There's also something else I want to add, introducing myself. And this is that I'm at present, after many years in the law faculty, I thought that it was enough, that I had to start something new. And then I moved to the Department of Education and Human Sciences, yes. And I am there. Happy to be there, and I teach comparative family law and child law, and that's all. I'm not going to say more about myself, and so I leave the floor to Chiara Graziani. I think we will hear all presentations, but just after hearing, just listening to the first and the second and the third, we will leave some time for questions, of course. I'm not going to say anything in introducing these session, and I just introduce the first speaker, Chiara Graziani. I leave the floor to her.
Thank you. Thank you. And once again, thanks to the Italian Association of Comparative Law and to the Younger Comparativist Committee of the American Society of Comparative Law for organizing this series of webinars. Maybe I have to say 2 times thanks for being able to rearrange the whole conference in the form of a webinar series, so allowing us to be here also in time of a pandemic. And thank you again, Professor Pamfolti, for chairing this session, and of course to all my co-panelists and those who are here to listen. Well, As anticipated, my work deals with the use of facial recognition in counter-terrorism operation and more generally in law enforcement operations. My work builds on the assumption that artificial intelligence is increasingly becoming a common feature of everyday life. As we know, it is used in a majority of fields, and among them also law enforcement and also counter-terrorism operations, so national security matters. This approach fits within a wider trend that sees technologies working as, we can say, a sort of third factor in the relationship between rights and security, which is already a very complex relationship. And this technology as a third factor of this complex relationship will be the key point around which I am going to develop my argument at the end of this presentation. Well, facial recognition, as I have also anticipated during when I introduced myself, facial recognition is an example of the use of artificial intelligence in its so-called weak meaning. Weak artificial intelligence means that we have an algorithm which is programmed in order to perform just some specific tasks. On the other hand, we have strong artificial intelligence, which means that the automated tool is able to replicate all the processes of the human mind, of the human brain. And currently, we have no examples of strong artificial intelligence because this is something that technology has not achieved yet. But starting from a very technical issue, what is facial recognition and how does it work? This is very important in order to understand well the implication in legal matters of artificial intelligence and facial recognition when applied to counter-terrorism. Well, facial recognition systems are biometric systems that have the task to extract and process biometric data by creating a so-called biometric template. Creating a biometric template means that an algorithm detects and measures several facial features of an individual, and then these features are used to teach the algorithm to recognize faces. Facial recognition has been the object of a definition of Article 29 Working Party that, as known, it has now been replaced by the European Data Protection Board, and it was defined as the automatic processing of digital images which contain the faces of the individuals, so clearly biometric data, for three purposes, which are identification, authentication, or categorization. And in all these three cases, so authentication, categorization, and identification, algorithms come into play. But how do they come into play? Which is their role? Well, authentication is when an algorithm has been trained to compare two biometric templates, for example, two facial images, in order to assess whether they belong to the same person. And this technology, we see it used, for example, for border check purposes at the airports. Categorization is the so-called face analysis. I mean that the algorithm is able to spot some common features of different faces. For example, is able to spot eye movement and also to link this feature to a certain event. For example, the fact that a person is not telling the truth and the algorithm will be able to recognize this from eye movement. Instead, identification is the most interesting function of facial recognition technologies if we want to analyze them from a counterterrorism perspective. Identification means that the algorithm is able to compare a person's facial image to many other facial images which are stored in a database in order to find out whether the image is stored in the same database. So, for instance, the algorithm compares the face of a person who, I don't know, is attending a public event to faces that are stored in a database of suspect terrorists. Well, facial recognition technologies, especially, as I said, the identifying ones, are being experimented by some countries. The most active in this field is the United Kingdom. We know the case of the South Wales Police, which used it in several large sports events and music events, specifically automated facial recognition tools used during the 2017 Champions League were even challenged in court with a famous and important decision of the Cardiff court. But I could also make some other examples. For example, in Germany, the Hamburg police used this kind of tools during the G20 summit in 2017, and also France is carrying out some trials in 2018. Furthermore, we have other examples of facial recognition tools in the field of immigration. At the EU level, this is particularly common. We have two very important regulations dealing with the integration of databases of member states, which also contain faces, so biometric data. And all these examples that I have just made deal with the use of facial recognition tools in the field of law enforcement or migration. Law enforcement for sure includes also terrorism, but it is not specifically devoted to terrorism, because law enforcement is something that is more wide, which is wider and more general than counterterrorism. But I could also make some example of facial recognition tool applied specifically to counterterrorism. For example, a project called Project First, which has been established by Interpol, and its aim is to help countries sharing biometric data to identify foreign terrorist fighters, but also some states of the United States are working to build this kind of tools and to use them in counterterrorism activities. So just in brief, facial recognition is being used as a new and particularly advanced form of surveillance, which is a specific technique used and resorted to in counterterrorism operations. Now, similarly to other facial recognition techniques and to other artificial intelligence techniques, facial recognition, if it is effective and if it works, of course, its aim is to facilitate law enforcement operation and also counterterrorism operation. But which are the constitutional implications of the use of these technologies? Well, the first and perhaps more evident problem is in terms of privacy. Facial images are biometric data, as I said, and biometric data usually gets higher protection if compared to other kind of data. For example, in the European Union, we have the GDPR, but also the Law Enforcement Directive, which is applicable in cases of law enforcement operation, and they recognize specific guarantee to biometric data. In the US, the framework is much more fragmented, but also there we have states which are adopting legislation to deal with the biometric data. And even if as I said, it is a bit more fragmented. It is some sort of patchwork legislation. So a second public law issue which arises from the use of facial recognition tools is the risk of violation of the principle of non-discrimination. This issue may depend both on inherent biases of the algorithm or on technical flaws. For example, let's think of an algorithm which is trained to recognize the faces of people. It scans the crowd and then it compares each face to a database of suspect terrorists. However, several studies, technical studies, demonstrated that this mechanism might be far from perfect. And these studies pointed out that algorithms face greater difficulties differentiating between faces of persons with dark skin. So, for example, dark-skinned people are more likely to be mistakenly matched to dark-skinned terrorists than white-skinned people are to be matched, for example, with white-skinned terrorists. And it is discrimination, and this discrimination depends on technical flaws of the algorithm. Now, as widely known, the principle of non-discrimination is enshrined in most domestic constitutions and international law tools, and there are huge number of courts decisions giving substance to this principle. Now, I don't want to argue that facial recognition is bad by definition in law enforcement and more specifically in counterterrorism practice, but for sure there is need that progresses in technology in this field, mostly in this field, take into consideration the flaws that may impact also, for example, on very basic principles of constitutionalism. And in this regard, I want to point out at least 3 points. The first is that the use of facial recognition tools and more generally the use of algorithms in counterterrorism and law enforcement operation, well, it makes even more evident than in the past that the relationship between rights and security is no longer a two-sided relationship. Technologies, as I said at the beginning, is a third factor that tries to sneak in this relationship and triggers a change of balance. This fact is true. It used to be true even before the widespread use of artificial intelligence, but now it becomes of maximum importance. Second point that I want to remark is that we are used to see that courts, in cases involving the fight against serious crime as terrorism, well, courts often focus correctly on the principle of proportionality as the key to establish the correct balance between rights and security. Now, with the spread of artificial intelligence, proportionality should still be the guiding principle, but it seems more difficult to implement the principle of proportionality with tools that are not completely governed by human beings. For example, courts said that non-discrimination is a strong component of any proportionate measure in the field of counterterrorism, but we have just seen how algorithms may pose some challenges in this respect. Moreover, proportionality may also mean, according to some courts' decision, may also mean transparency, but algorithms are not framed in a transparent way, are not built in a transparent way. And therefore, one of the major issues is likely to be which judicial standard should be resorted by courts. third and last point I want to highlight is that the creation of facial recognition algorithms, like many other artificial intelligence tools used in counterterrorism, well, it means that private corporations are often involved as key partners of public authorities in order to concretely arrange these algorithms. Well, this partnership is full of very important legal implications. First of all, the most evident derives from the different goals that the public and the private sector pursue in their activity. Well, these were just some points, just some insights that emerged from my ongoing analysis on these aspects. Whilst in the debate, I will be glad to discuss them further. So many thanks for your attention.
Well, thank to you for this extremely interesting presentation. The topics you raise are really hot, I would say. I think I have a question, a remark from Professor Zenkovic. Yes, I think it's better if we have a question and answers now, just after. Was it your idea, Vincenzo? Yeah, you are muted.
Yes, I think on the whole, question and answer session is also in our present seminars. It works better if the question and answer immediately after, because when we've had many speeches, then it becomes difficult to remember what what other previous speakers have said. So just wondering if there are questions from public. I would just ask Chiara Graziani if you can lower slightly the volume of your computer, because
yes,
there's a lot of noise that comes back.
Yeah, sorry for this.
I'm sorry, can you hear me?
Yes, yes.
Yes, we
Yes,
can.
okay. Any questions? We're starting from across the Atlantic.
It's a very interesting topic, and I've heard about it in general terms, but it was quite interesting to hear more specific issues that it raises. One thing that strikes me, and I'd like to hear Ms. Graziani's view on, is this kind of technological change is really simply doing something we've always been able to do, but do it better. So that facial recognition, right, is as old as human beings, and we've never been worried about that, about simply remembering what someone's face. In the issues that you raised, for example, with regard to discrimination, that's a vice which, again, human facial recognition has been subject to forever. So I was wondering whether, in fact, there's something different about this, more dangerous about technological facial recognition than there is for human facial recognition.
Yeah, so thank you for this remark. Yeah, I do understand it, and I think that yes, there are some more dangerous issues which are linked to facial recognition made by machine, which is exactly the fact that you are not able to govern the machine, because this kind of tools are self-programming tools, and so they could also make some mistake that do not depend even on the programming from the human being. And so in my view, in my opinion, this is the most dangerous feature which is linked to facial recognition by machines, by automated tools. As I said during my presentation, I do not want to argue that they are bad by definition, but I think what I want to expose, what I want to say is that they are specifically changing maybe our view on some specific categories of constitutional law and of comparative law. And yes, I think that it depends on exactly on the automation which is behind this kind of tools.
Mm-hmm. Professor Zenkovic ha una domanda.
Yes.
Poi mi pare di capire anche Pier Giuseppe Monateri, se non sbaglio, c'è una cosa che non capisco sulla chat.
No, well, generally one raises one hand, one goes on chat, on participants and lower hand or raise hand. Anyhow, just I wanted to ask Graziani this, a first comment. Obviously, the efficiency of artificial intelligence depends on the amount of data you have, and therefore, if you have, it is quite obvious that in a European database, you have obviously white faces, and obviously it is rather difficult to recognize someone who's Chinese, just to make an example, and therefore you make great mistakes about that. So the problem is how much data you're going to put in this database. I mean, to have a good facial recognition of Chinese individuals, Chinese I'm speaking of, let's see, of Eastern European, Eastern Asian people of ethnicity, you would need a huge amount of data that you have to ask Chinese, Japanese, Vietnamese to give to you. So this is the first element. But what my main concern about facial recognition is this. As we know, with terrorism, the only way is prevention. It makes no sense to do an investigation about who did a terrorist attack. Yes, you can do it, but I mean, you can but it's not so useful to know once a terrorist attack has happened, because its effects have been deployed, and that's done. I mean, what you're trying to do is save human lives and all the political consequences that come from the terrorist attack. When it comes to other crimes, just let's make money laundering, human trafficking, drug trafficking, or whatever not, well, obviously you would like to prevent that, but well, you can also somehow catch the criminals and put them to jail and bring them to trial. Now, my main concern is, and this is the question to Dr. Graziani, is that in the European Union, we have extended certain kinds of security measures from terrorism to serious crimes. And one looks at the list of serious crimes and one finds some petty offenses that make no sense. So you think that facial recognition can, as today, according to the existing laws, be used also for investigating not terrorism, but other kinds of crimes?
Well, thank you. Thank you, because I think that you raised two very important issues which are related to facial recognition, but also more generally to the use of artificial intelligence in this kind of activities. The first is the amount of data. And yes, I do perfectly agree with you that the efficiency of artificial intelligence tools depends on the amount of data. But on some jurisdiction, as you said, you can have, for example, more white people, and this could be the bias that cause artificial intelligence tools to make mistakes. And also, I think that on the other end, there are also the fact that some data are better protected in some contexts, for example, in the European Union, and this could even make the consequences that the algorithm has less data to be trained on. And so I think that, which is a kind of protection in terms of data, could also become a kind of diminishment of the efficiency of the algorithm. And here I think that we have the specific issue of the balance between what amount of data should we take from people in order to be able to train our artificial intelligence tools in order to, and I come to the second limb of your question, to prevent terrorist attacks. Because yes, prevention is the main tool against terrorism, because I think it depends on the fact that terrorism has wide implication and wide consequence, whilst other crimes may have also, yes, wide implications, but with terrorism it is different because you don't know when it happens, in which context, and so on. So yes, I think that the question is more traditional, because it is the balance between prevention and repression of terrorism and in general of crimes. And I think, yes, we can accept a much more preventive attitude, but at the same time we have to remember the principles of the rule of law that, as I said, are enshrined, for example, in European Union regulations and in the Charter of Fundamental Rights. And yes, I think that here there is a sort of conundrum, because it is a specific context in which the protection of more data may cause a diminished efficiency of artificial intelligence tools. So yes, this question put behind a very important conundrum, I think, of counterterrorism operations and measures. So thank you. This is an aspect on which I will go in depth, because it is very, very important for this kind of research.
There are other questions. Shouldn't I have an icon with raise hands or something? I don't see. Vincenzo is answering, but I don't hear. You are mute.
Marianata, if you go down to participants, at the bottom of the screen, you find participants. At the bottom of the screen, you see participants 47. You click on that, and you have the distinction between panelists and attendees, and obviously you can, if you see a raised hand, for example, now I can raise a hand. You see, if you see now I've raised a hand, and then
yes, I see here.
Yes, there's a little blue sign that tells you panelists, but I don't see, apparently I don't see other interventions here. Nobody else has raised a hand, at least among the panelists. So I think we can move on to the next.
Before we move on, that's exactly what we are going to do. Could I say just a word to Chiara? And this is it's a remark. It's not a real question, and this is just to show how important it is, this topic, also in the field of family law. Because if we think of collaborative robots, then for instance, in the field of those machines which are a help for people with cognitive problems or impairments, then in that case, those cases, it is important to identify the members of the family who can give inputs to the robot. I mean, of course, it's a completely different field, and the problems are completely different. But still, what I wanted to remark is that this topic is not important at all in this, let's say, public relations field, but also in more narrow area of family law. And that's all.
Yes, thank you. Of course, I agree, because I think that artificial intelligence is one of the fields in which the interdisciplinary approach is easier to see. So, of course, this is true between public law, private law, but also I think with regard to disciplines and to fields that are completely different from law. And so, for example, with informatics, there is an intersection, and with also other technical and scientific fields. So yes, this is of course true, and I am very happy to have been here, the chance to see how interdisciplinary this field and this topic is. So thank you.
Thank you. And now to Nausica Palazzo.
I would like to share some slides, if you don't mind. Okay, so I think you should be able to see it. Okay. So good morning, everyone. Again, let me join Chiara in thanking the organizers. I've seen Antonia Baraggio in the list, so I would like to thank her and all the organizers for setting this up, and also for moving it online. I know.
Sorry, but I don't see anything on the screen. I don't know. Does anybody else see anything on the screen?
I don't.
So
no, I don't.
What you should do is that it should be already whatever you want to show on the screen should already be on your screen, okay. Not a file. You should just already open it on the screen, and then you share screen, and then you click, your screen will appear, and you click on the image that you want, or the slide that you want to show.
Okay. Is this better?
Yes, that's it. APE, yes, we see the APE. Okay, that's great.
Perfect. Okay, so I think you will see the whole thing though. Okay. Okay. Let me start introducing my topic. So the title is Queer and Religious Groups, a Shared Interest in Family Legal Pluralism in Western Societies. And let me start from this basic observation that family law is too often nowadays out of touch with the reality of family structures, because I think we nowadays are going to enter a post-same-sex marriage world, in the sense that same-sex marriage is recognized nearly everywhere in the Western world, or it's going to be recognized nearly everywhere in the Western world. So this leaves the question whether is it over, the struggle for the recognition of new families. And my impression is that it is not, because we have a much more complex landscape of modern families that do not align with the traditional, let's say, traditional model of family. There is a family which is preferably dyadic, romantic, exclusive, which has a sexual component, and nuclear, so again, preferably with children. And therefore, I'm thinking about a whole lot of families, such as non-conjugal families of siblings and friends, also who lack a sexual component, but also polyamorous families, but also a lot of religious-based normativities which do not resemble the traditional notion of family. So, of course, this creates the fact that law does not necessarily recognize this variety of families creates a gap, a growing gap between, on one side, law, and on the other side, the reality of families. But what I call, and what I do not, Guido Alpa calls a state monopoly over family laws, means that the state is utterly interested in regulating families. So it's utterly interested in, for instance, regulate access to and exit from marriage, but also other family regimes. Is interested in choosing which are the families which deserve legal benefits, including important material benefits. And it's interested in determining which is the forum to resolve family disputes. And the reasons for this state monopolies are many, of course, and I explored those in my research by pointing, for instance, to the Foucault legacy of what he calls the biopolitical end, whereby the state takes possession of the bodies and covers these bodies with its technologies of regulations, but also the so-called channeling function of family law, whereby the state channels the reproductive function into stable family units to perpetuate the species, so on and so forth. So it's all about state-mandated goals, again. But the most important chunk, I would say, of my research concerns the rich scholarship on legal pluralism, a notion which refers to the idea that in any space within the geographic boundaries of the nation state, there is more than one law or legal systems. And I'm especially interested in that scholarship looking at how legal pluralism plays out in the field of families, in family matters. And I'm especially interested in the so-called religious side of the debate and the queer side of the debate. Let me just point to the first. So the religious side of the debate tells us that there are really a lot of religious-based normativities which do not resemble the traditional families. I'm just to mention a few. I'm thinking about polygamous unions which are favored by a splinter group within Mormons, but also Muslim families, but also Jewish chain marriages, that is those marriages that can only be dissolved upon the consent of the husband. Covenant marriages, again, enforced in 3 US states, among which is Arizona, Louisiana, Kansas, whereby you can only dissolve marriage in very, very limited circumstances, such as the most egregious forms of domestic violence. So I think it's interesting because it tells us that autonomy cuts both ways, in the sense that it can also lead people to have more conservative regimes, not necessarily more open, progressive regimes. So people can decide to self-impose a more strict family regimes, which is the point. The point, I think, is the common interest that religious groups and queer groups on the other side in recognizing more families through more family regimes by enhancing the principle of self-authorship, self-determination in family matters, religious freedom where applicable. And it really touched upon the idea that it's not about law subjects, but it's about law users which can contribute to determining what's the law, which should apply to their personal matter, to their family matters. And that's, of course, the queer side of the debate, which really puts a lot of emphasis on recognizing families beyond dyadic families. I'm thinking about polyamorous relationships between, even beyond dyadic requirements, beyond cohabitation requirements. For instance, there's a whole lot of literature on people living apart together, so on and so forth. So my research goal is basically to explore how we can look at the gap between law and modern families, and what are the potential ways to reduce this misalignment, aware that the state is still very much interested in holding its tight grip on families. So perhaps some religious groups and queer groups might converge and recognize that they might have shared interests when it comes to family regulation, especially two interests, I think, they have a shared interest in recognizing more recognition mechanisms, something that the US literature calls family legal pluralism. And I noticed this during my doctoral research, where I saw that in some Northern American states, the most conservative fringe groups were actually introducing the regimes that were more open and preferable in terms of queer theory, notions of family. And I'm referring to Alberta, a province in Canada, for instance, where conservative and Christian groups actually introduced a scheme to recognize friends and siblings, with a view to prevent, in 2001, the recognition of same-sex marriage. But the very same dynamic applied to other contexts, such as Vermont, such as Hawaii. So they might have an interest in different family regimes, non-marital family regimes, even though sometimes these initiatives might be driven by animus towards same-sex families. They also might have a pretty strong interest in recognizing families beyond the traditional families. That is, again, non-dyadic families, or again, more conservative view of families. So I start with two research questions, and I ask first, where did this group converge in the past? So I will look retrospectively at the cases where they might have actually converged in the past. And two, what are the bases for further convergences in Western legal systems? And what are the strengths and weaknesses of this basis of convergence? So my methodology is based on the comparative method, and it's a mainly document-based legal research, and I will focus on the North America, Canada, and the US, and France and the UK as to Europe, where I will look at the cases that I was mentioning before, Alberta, the case of the reciprocal beneficiary schemes in Vermont and Hawaii, but I will also look at the case of the Pacte Civile de Solidarité in France, because during the debate surrounding the introduction of the law, there were some persons who were very much in favor of opening up the regime to siblings, to friends as well. And the same applies to the Civil Partnership Act. Although in the case of the Civil Partnership Act was really driven by animus towards same-sex couples. Then I will look prospectively to the potential sides of reform, and I will focus on the recognition of an alternative family regime to marriage, that is, of a flexible registration scheme that can perhaps be modeled after the cohabitation légale in Belgium, which is a very flexible registration scheme where any two persons can register and gain quite a lot of marital benefits, nearly all, but with some exceptions concerning survivor pensions, so on and so forth. And the second ground of convergence could be the recognition of non-dyadic unions, which might bring, again, some Muslim communities and Mormons to recognize that they do have a shared interest when it comes to recognizing these kind of families. So before stopping, I would like to say that I think that the reason why I'm also working with the Fondazione Bruno Kessler Center for Religious Studies is their interest in moving beyond traditional narratives around family law activism, that is the American style notions of clash, culture war, the fact that conservative and progressive groups are always pitted against each other, pro-life, pro-choice. But I think that this narrative really misses the point and really overlooks many religious groups that are not necessarily do not necessarily object to most instances and to most policy objective that progressive groups have, and I've listed some cases where I noticed that. So this is what I'm going to do in the next few months and probably years, look at the extent to which some groups on both sides share an interest in illegal pluralism in the context of family law. I think I'll stop here. If you have any question, feel free to ask. Thank you.
Yeah, thank you, Nausica. Really, thank you. It was extremely interesting. Your paper was extremely interesting. I have a question, but I will not be the first to ask this. Someone has raised a hand. Am I wrong? There was a question. No?
Right, Maria Donata, I have a question, but it's more for Professor Kay.
Oh, yes, please do. Do you want to ask the question now?
You go ahead, go ahead.
I had a very simple question on method. You said that you tried to understand how things went in the past and how the religious and queer groups converged. You wonder whether this happened in the past. And I would like to ask you, which sources do you have for these? Which materials do you use to get into this topic?
Okay, thank you very much. This is a very good question in the sense that since this debate took place in 1991, 2000, we don't have, I personally didn't have access to the travaux préparatoires, and I didn't have access to much beyond journal articles and social legal scholarship. So it's an academic debate that I'm drawing on to discuss this topic.
Yeah. Yes, I understand that this might be there might be a problem to get into this, to have knowledge of what really happened. But it will be interesting, extremely interesting to follow your research.
Thank you. So I was also considering doing empirical research, but first I don't have, I don't know, I've never applied empirical methodologies. So I was very skeptical about doing that because Fondazione Bruno Kessler has a mixed, likes very much empirical approaches to legal research, but I refuse to. I have considered doing some qualitative research, so try to reach some such groups, but then I decided to limit myself working on legal research.
Yes, it is reasonable, really. I see Professor Zeno Zenkovic wants to ask.
My question is this, but it's maybe more to Professor Kay because he's nearer the sort of where things might change. I'm very sensitive to the topic. As some of you may know, I've been of counsel in the cases of same-sex marriage and stepchild adoption in front of the Italian Constitutional Court. So I'm sensitive to the issue. But I have this impression that not only in some European countries, but especially in the US, they may be going too much ahead in certain forms of, family agreements, of legalizing certain forms of union will bring to a backlash, and this might bring to coming back to certain certain sort of results that have been obtained over the last 20, 30 years. So I'm just a question to you, but mostly to Professor Kay, is do you feel that maybe they may be somehow a return to the past? For example, that the new U.S. the majority in the U.S. Supreme Court might somehow reverse Obergefell, simply following Scalia's position, which to me seemed, convincing from a sort of a strictly, putting it from a very strict point of view, saying this belongs to the states. So it's up to the states decide whether they want to have same-sex marriage or not. It's a one position which was, you read that, and I'm not an American constitutionalist, so I'm not going to object to Antonin Scalia, but do you think this could be something that might come out in the next years, especially with this U.S. Supreme Court and with certain positions in the U.S. society?
Should I go first?
Yes, please.
I'll ask, I don't know, you just play between yourselves.
Go.
I'm sorry, did you want me to answer now, or is Ms. Palazzo going to go first? Someone's muted.
Just as you please.
Let me speak to your question, which is, as you can imagine, a complicated question. You mentioned kind of a backlash from the expanded recognition of different kind of familial relationships. And we can look at that two ways. One is a cultural backlash. But as to that, I am very doubtful that there has been that kind of a reaction which would put in jeopardy the changes that have taken place over the last 15 or 20 years. That different attitude towards same-sex marriage and in general towards unorthodox family relationships occurred. I couldn't have predicted it. It occurred very rapidly, but my view is it is fairly, very widely held. The second question you asked is a much more narrow one about what can we expect from the Supreme Court after the recent appointments of Justices Kavanaugh and Gorsuch. And here I'm just not sure. We have yet to have a case, a well-known controversial issue before where there might be an overruling of a prior case has not yet appeared. These judges are quite new. We are going to see, we'll get some kind of a hint from that after they decide the abortion case that is currently on the docket. If they are going to overrule Roe versus Wade, then I think all bets are off, and we have no way to know what they won't overrule. But it's entirely possible. My expectation is that there will not be this kind of overt change in doctrine, and that these judges will find a way to uphold restrictions on abortion without overruling Roe versus Wade. And that would be a sign of a somewhat more cautious attitude. The question is here about precedent, and Obergefell is a fairly recent precedent. But I have to say, I'm a terrible predictor of Supreme Court decisions. Can't put too much stock in my forecast.
Can I add just a quick note?
Yes.
So I would just like to add that some academic lawyers are already talking about plural marriage. So the recognition in the United States of non-dyadic marriages. This might lead to a backlash also that also impacts same-sex marriages. So I concur with Professor Kay that I don't think there's going to be much change in terms of what we call acquired rights, but there might be a backlash on same-sex activism, same-sex persons, if we probably keep talking about expanding marriage further to include more than two persons. That might be a dangerous narrative, I think. So this is why my research also wants to shift attention outside marriage to talk about different recognition mechanisms that are also better, somehow better than marriage in terms of their features that are more flexible and less traditional regimes.
May I can mention one thing, just which you may already know about, and that is just within the last month, a law went into effect in the state of Utah, changing the status of polygamous marriages. Haven't made it legal, but they have reduced it from a criminal offense to a civil offense.
Yeah.
And so that's kind of the point you just made about polygamy. That is, changes there are sort of in the wind. And Utah, of course, is a complicated state when you try and analyze that issue. So it may not be easy to draw generalizations.
Donata, may I?
Yes.
May I just?
Yes, you may.
Yeah.
Of course.
Okay, thanks. I hope you can hear me. Hope so.
Yes.
All right. Well, as long as it is a matter of rights, I don't think that the shift toward recognition is so simple. I mean, if it is a matter of Ninth Amendment or any way of right to have a personal scheme or arrangement of family relations recognized, just focusing on recognition process is substantially avoiding the major issue, isn't it?
Can I ask you, what is the major issue in your opinion?
Okay, the fact of having a right or not. I mean, from a constitutional point of view, I think it is a major issue.
Sorry, I couldn't hear your voice.
Okay.
Apologies.
Well, I think that the fact of having or not having a right, it is the major issue, much more than just a process of recognition.
Mm-hmm. Okay, so it's a matter of rights. Okay, I wonder what is a different way to get to obtaining legal rights beyond, you mean beyond status?
I mean, just in the terms of the Ninth Amendment of the American Constitution.
Mm-hmm. Oh, I see.
Okay. That was exactly the frame in which many Supreme Court decisions framed the problem of marital privacy or, anyway, marital relations.
I see. I don't have I don't have an answer to that because.
Okay.
No.
Well, let me, since you raised the U.S. Constitution, I can't help but get back in. Let me, if you don't mind, correct you somewhat. That is, most of the so-called right of privacy cases decided by the United States Supreme Court have not been based on the Ninth Amendment.
No.
The Ninth Amendment is it's an issue in itself. In some of those cases, especially in the birth control case, Griswold versus Connecticut, there was a concurring opinion, which by I think it was Justice Goldberg, which relied on the Ninth Amendment. And there have been individual judges who've raised it, but the majority of those cases are decided under the due process clause of the 14th Amendment. I'm sure nobody wants to start going down that road this morning, but this afternoon. But it is, and I would say that to your point, the extraction of substantive rights from the 14th Amendment is every bit as difficult and problematic as is the case for the 9th. But I say we probably don't want to start down that road. Find it hard to find our way back.
I think that for reasons of time, it's if there is no other question, and I don't see any other hand raised, I think it's better if we move on to our next speaker, Francesca Raimundo. And please, Francesca, before starting your presentation, just say a couple of words about yourself.
Yeah. Good afternoon, everyone. I hope that you can hear me now. I'm deeply sorry for the inconvenience earlier. I don't know what happened. And I'm Francesca Raimundo. I have completed a PhD last year at the University of Bologna in legal studies. My thesis was in comparative public law and focused on citizenship and how citizenship is under pressure in a pluralist society. At the moment, I'm doing a postdoc at the University of Louvain, and I'm focusing on immigration law, and in particular on vulnerabilities of protection seekers. Okay, and I'm joining the other two speakers in thanking the organizer for setting up this and for the opportunity of having me here. I will try to share my screen to show you some slides if I'm lucky enough to do both, to make me here and show you some slides. I will try. Can you see?
Yes, we can see them. Yes, that's fine.
Okay, thank you very much. So today I'm going to focus on the relationship between citizenship and religion and how this relationship is changing in contemporary diverse society that are increasingly multi-ethnic, multilinguistic, and also multi-religious. And to do so, today I will use mainly the example of India, that for the first time in her history, in her democratic history, from last December, the idea of citizenship is explicitly related to a particular religion. The relationship between citizenship and religion is rooted in a more complex articulation of the relation between religion and state sovereign power, and could heavily be affected by issue of interfaith coexistence. And lastly, since both citizenship and religion identify a membership in a community, on the one hand political and on the other hand spiritual, this relationship is strictly intertwined also with the issue of individual, collective, and national identity. I will focus on the Citizenship Amendment Act that passed in India last December. I will explain how and why it is in contrast with the Indian constitution, and then I will reason on the current backdrop in which this act has been approved by the parliament. And finally, I'm going to share some last reflection on which role is playing religion with regard to citizenship in the last decades. So the Citizenship Amendment Bill in India was approved last December from both houses of the Indian Parliament. The lower house, the Lok Sabha, where the Indian People Party has the majority. The Indian People Party is an Hindu nationalist party that has the lead of government since 2014 with Prime Minister Narendra Modi, and in the upper house, the Council of State. This was not the first time that the act has been put before the parliament. There has been another attempt in 2016, but even though the bill has passed in the lower house, it did not pass in the upper house after violent protests in northeastern India. What the bill states? The bill amends the Citizenship Act 1955, which details the mode of acquisition and loss of citizenship in India, giving fast-track citizenship to religious minority groups through two main amendments. We should say first that Citizenship Act of 1955, after the reform of 2003, and I will come back to this reform later on, prohibit illegal immigrants from obtaining Indian citizenship by registration or naturalization. Illegal immigrants are foreigners who enter India without a valid document or that overstay their visit. And they can be deported or jailed, but in any case, they cannot acquire citizenship by registration or naturalization. The Citizenship Amendment Act introduced an exception to this rule because it states that 6 religious minority communities, and more specifically Hindu, Sikh, Buddhist, Jain, Parsi, and Christian, that come from Afghanistan, Bangladesh, and Pakistan, and that have entered India before the 31st or on the 31st December 2014 can obtain citizenship by registration or naturalization despite their illegal entry in India. The second amendment to the Citizenship Act 1955 is the reduction of the minimum residence period for naturalization. This period has been reduced to 5 years as opposed to the earlier requirement that was of 11 years. In the statement of object and reason that you read in the slide, that is a document appended to the bill that provides the reason and the context behind the passing of the bill, is written that many persons belong to the 6 religious community that I've just mentioned have faced persecution on ground of religion in the country, Afghanistan, Bangladesh, and Pakistan, that we should remember are 3 countries where the majority is Muslim and that have a state religion. And some of them also have fears about persecution in their day-to-day life, where right to practice, profess, and propagate their religion has been obstructed and restricted. And many such persons have fled to India to seek shelter and continue to stay in India even if their travel document have expired or they have no document at all. Even though the amendment looked at first sight as a benevolent pathway to Indian citizenship for religious minority that fled persecution, and the government affirmed that it will give a sanctuary to people fleeing persecution in the 3 neighboring countries, it has been widely perceived as an overtly anti-Muslim citizenship reform, since the silent implication is that Muslims from these 3 countries would continue to be treated as illegal immigrants and therefore would not be eligible for citizenship. The act has prompted widespread protests both from those who oppose the act for being discriminatory and the violation of the secular principle enshrined in the preamble of the Indian Constitution, but also from the northeast state of the country, which borders with Bangladesh, because of the fear that this part of the country will be overrun by immigrants from across the border. Why this act is unconstitutional? More than 140 petitions have been made to the Indian Supreme Court that has to decide on the constitutionality of this amendment. Scholars have defined this act not only unconstitutional, but patently, manifestly, and obviously unconstitutional. The reform appears to be in contrast first and foremost with the principle of equality established in Article 14, which guarantees to all persons equality before the law and equal protection within the territory of India. The differentiated treatment reserved to some religious groups are not based on justifiable and reasonable ground and do not correspond to the proclaimed purpose, given that many other not religious groups are left out from the amendment. More specifically, I'm referring to Muslim or member of other religious community who may have faced persecution in Afghanistan, Bangladesh, and Pakistan, such as the 2 Muslim sects that are persecuted in Pakistan and Afghanistan, and I'm referring to the Ahmadiyyas in Pakistan and to the Hazaras in Afghanistan. More specifically, the Ahmadiyyas in the Pakistani constitution are defined as non-Muslim. The second group that is excluded are the groups persecuted for their religion in other neighboring countries. Most notably, Rohingya in Myanmar, that is a Muslim ethnic group and is well known because it's a stateless group, or Tibetan Buddhist in China, but also refugees from Sri Lanka, Nepal, Bhutan, or countries that are not Indian neighbors. Another group excluded are a group persecuted on grounds that are not related to their religious affiliation, such as persecution, and so they are persecuted for example, for ethnic, linguistic, or political reason. And again, here we find the Tibetan in China, or the Tamil group from Sri Lanka, who are predominantly Hindu and represent one of the largest refugee groups in India. Or lastly, people who have illegally entered in India after the 31st of December 2014, that is the cutoff date established in the Citizenship Amendment Act. The exclusion of many persecuted communities in the scope of the Citizenship Amendment Act without a reasonable and justified reason casts a doubt on the humanitarian aim of the Act, that is to accommodate minority groups that face religious persecution. In addition, the eligibility to a fast-track citizenship is not based on an assessment of an actual persecution. We should remember that the Act does not specify that evidence, if any, would be required in order to claim of having been victim of religious persecution. Moreover, the Citizenship Amendment Act breached also Article 25 that protects freedom of religion for all the persons and not the citizen in India. And lastly, is in contrast also with the secular character of Indian democracy that is established in the preamble of Constitution. The preamble was modified in 1976 when the word secular, socialist, and the reference to the integrity of the nation were added. I say the Supreme Court is currently scrutinizing the petition challenging the constitutionality of the Citizenship Amendment Act. And according to some scholars, this will be a crucial test for the legitimacy of court in India. What is the context in which the act was approved? The Citizenship Amendment Act gave extra fuel to very complex issues that concern India. First and foremost, the long-standing matter of trans-border migration between India, Pakistan, and Bangladesh after the partition. The partition is how it's called the disintegration of British India and the creation of two sovereign states of India and Pakistan that occurred in 1947, and the creation of Bangladesh that was later on in 1971. That earlier was part of Pakistan, was called East Pakistan. Other issues come into consideration, for example, the treatment of minorities, and among them of specific religious minorities, I'm referring to Muslim, and the fact that India is not a signatory of any convention on refugee or statelessness. The reform has been preceded by two amendments at the Foreign Act and Passport Entry to India Act, thanks to whom illegal immigrants, members of same religious minority mentioned in the Citizenship Amendment Act, coming from Bangladesh, Afghanistan, and Pakistan, who were compelled to seek shelter in India due to religious persecution or fear of religious persecution, were exempted from deportation due to their legal entrance. And the following year, the government issued two orders that made the same group eligible for a long-term visa. Furthermore, the Citizenship Amendment Act is the top of the iceberg of a slow but steady shift that is occurring in India from a civic national to an ethnic national citizenship, realized in two ways. First of all, through the shift in the mode of acquisition at birth from jus soli to jus sanguinis, thus privileging the individual descent. And then through the shift from a secular citizenship law to a law that is strictly and nowadays overly intertwined with the religion and that put in a profound disadvantage some groups. Therefore, India scholars have affirmed that this act, together with the National Register of Citizens, and I will come back to this in a second, are radically transforming Indian citizenship. The Constituent Assembly opted for jus soli that was considered at the time enlightened, modern, civilized, and democratic, as opposed to the jus sanguinis that give the idea of racial citizenship. India's citizenship law passed from a predominantly jus soli regime to a regime heavily influenced by jus sanguinis through two main amendments in 1986 and 2003. And both amendments were taken in response to migration from Bangladesh into Assam, that is the Indian state at the border with Bangladesh, especially after the creation of this latter country. More specifically, the 2003 amendment undermined the principle of jus soli and introduced covertly a religious-based exception. It established that a person born on Indian soil will not be eligible of Indian citizenship by birth if one of the parents is an illegal migrant at the time of the birth. Since the majority of illegal immigrants are Muslim Bangladeshi, the 2003 amendment has been considered and defined by many scholars as a precursor of the amendment that is under scrutiny today. As anticipated, the Citizenship Amendment Act is strictly connected to the National Register of Citizens. The register is the official record of those who are legal Indian citizens. Even though the register has been prepared for the census in the 50s, it has been updated only recently and only for the border state of Assam. It has been a massive process that took 4 years and that was monitored by the Supreme Court of India. The declared aim was to detect and then deport illegal immigrants who come to Assam at the time of the creation of Bangladesh. Therefore, only those that can prove of being Indian at that time, a day before of the independence of Bangladesh, will be part of the national register. Last August, the final National Register of Citizens have been released, and 1.9 million of applicants have been excluded. In other words, it would represent the biggest mass disenfranchisement of the 21st century. And the situation in Assam has therefore been recalled also in the opening statement at the 42 session of the Human Rights Council last September by the UN High Commissioner Michelle Bachelet, who made an appeal to the government to ensure due process during the appeal and ensure that people are protected from statelessness. Many found a common thread between the Citizenship Amendment Act and the National Register for Assam. In particular, Jahal, one of the most prominent scholars of Indian citizenship, said that the Citizenship Amendment Act creates path to citizenship, but only for preferred groups. To read preferred religious groups, and the NRC, the National Register of Citizens, that creates path to statelessness for groups that are disfavored. Even though it has been asserted in Parliament by the government that the National Register of Citizens and the Citizenship Amendment Act are not related, many find the link for at least two reasons. First, since the vast majority of illegal immigrants that came to Assam are Muslim Bangladeshis, this is another covertly religious-based tool that excludes Muslims from citizenship. And secondly, last November, the Home Minister declared that the register would be extended to the entire country. Therefore, those who would be eventually excluded from the register because they are illegal immigrants, if belong to the favored religious community mentioned in the Citizenship Amendment Act, not only will not be deported, but also will acquire citizenship thanks to the provision of the Citizenship Amendment Act. So, in other words, Muslims will be excluded. However, there are scholars that think that both Muslim and non-Muslim community would be in danger with both these instruments, because it should not be taken for granted that those who excluded from the Citizenship Amendment Act, from the National Register, I'm sorry, will automatically be included in the Citizenship Amendment Act. What the Act tell us with regard to citizenship and religion? As affirmed by an Indian scholar, the Citizenship Amendment Act is the latest law which forms part of the ambitious legislative reform agenda of the ruling regime in India. The Hindu Right, a right-wing religious and nationalist movement which comprises also the Indian People Party that lead the government since 2014 with Narendra Modi, has embraced the ideology of Hindutva. That means the establishment of India as an Hindu state. The Hindu Right has always pursued a narrow conception of citizenship, privileging cultural and religious identity. At the time of the Constituent Assembly, one member advanced the proposal that every Hindu and Sikh, wherever they reside, shall be entitled to the citizenship of India. Therefore, doesn't go too far those who have claimed that the Citizenship Amendment Act is similar to the law of return of Israel, which stipulate that every Jew has the right to come to Israel and take up citizenship. This law has been central in securing a Jewish majority in Israel, but at the same time has been among the main reasons why Palestinians are the largest stateless community in the world. I think that the Citizenship Amendment Act in India can be somehow also connected with the phenomenon that can be defined culturalization of citizenship that is occurring in the Western world, and I'm referring mainly to Europe and North America. Let me give some examples. Many countries in Europe and North America as well have introduced civic citizenship tests alongside linguistic ones that in some cases, like for example, Netherlands and Germany, correspond also to a morality test with a question that somehow related to the candidate's religious beliefs. Another example is the mandatory citizenship ceremony with compulsory handshaking introduced in 2018 in Denmark, and that has been recently suspended only for reason of COVID-19. Handshaking requirement is controversial and has a clear religious meaning because some people, for religious reasons, don't want to get in touch with the others, and especially with people of the opposite sex. Moreover, another example is the rule adopted in Canada from 2011 to 2015, according to which new citizen has to swear the oath of citizenship with their face uncovered. That means actually that women that wear the full face covering were implicitly excluded, or they have to unveil themselves. And with regard to veil, there are many examples in France, and I will recall only two of them. The decision of the Cour of Appeal of Nantes that state that naturalization had to be denied to an Algerian woman who, as a member of the League of the Muslim Women, encouraged the use of the veil, because in the opinion of the court, this behavior has to be considered of religious extremism. And another one, a similar decision that was taken by the Conseil d'État that rejected the naturalization of a Moroccan national because she was not sufficiently assimilated in France because of her radical practice of wear the full face veil. Therefore, the Citizenship Amendment Act is the top of the iceberg of what could be defined progressively culturalization of citizenship, because for the first time in a secular country, religion is overtly connected with citizenship, and the religion perform a clear selective function, both with regard to path towards citizenship, or in some cases also to path to statelessness. India showed that this phenomenon is happening not only in the Western world, but also in countries that, as many other countries in the British Commonwealth, have a long-standing practice of ethno-religious pluralism. And even though India has not constitutionalized multiculturalism like Canada did, it has what has been defined as unstated, unofficial, unproclaimed multiculturalism since the inception of the Republic in 1950. Thank you.
Thank you. Thank you, Francesca. Thank you, really. It was extremely interesting and inspiring. And again, I have a question, but I will not the first one to make it. If someone else wishes to raise a hand. It appears that up to now, no one is asking. Can you hear me? Yes. So my question is a very simple one, and I don't know much, I must confess, about this topic, but I was wondering whether the newly introduced rules do have any specific provision about children. I mean, the rules apply indifferently, I understand, without any distinction of age. Is it so?
Yeah, this is the case. The amendment does not make any difference, and the only two features that are required are that people come from Bangladesh, Afghanistan, or Pakistan, and that they belong to one of the religious community that I mentioned. And of course, there are many problems connected to these two features, because first of all, it's a discriminatory one. But secondly, how there are no way to show how this community are subjected to any persecution, because it doesn't mean that because the three countries taken into consideration have a state religion, is not directly connected to this, that there are other communities are discriminated or are subjected to persecution. We have many examples of countries that have state religion. I'm referring to the Nordic country in Europe, or for example, most notably UK. And this doesn't mean that there is a overtly discrimination or other communities are persecuted. And so there is no specific provision for children, and the only two features are the one that I've just mentioned.
Sorry. Can I?
Yes, please.
Okay. I'm very sorry, but I didn't grasp. the example of the Palestinians. Does it fit with the other things you said or not?
I'm sorry, maybe I was a bit fast in explaining the connection with Palestinians. I actually was making a connection between the Citizenship Amendment Act and the law of return of the 1950 in Israel, that actually gave the citizenship to all the Jews all over the world that were returning to Israel. And even though Palestinians, of course, were not included because they were not Jewish, they are not Jewish, usually they're Arab Palestinians, they were excluded, therefore implicitly excluded from the 1950 reform. But also the law in 1952 on citizenship in Israel, so not the law of return, the general citizenship law in Israel of the 2 years later, set very strictly residency requirement, and therefore these two laws has a result made that many Palestinians that were in that area before the 1948 became stateless. And this will be the result also for Muslim community that in case the National Register of Citizens would be applied also for the entire country in India. So that's why there was this connection. I'm sorry if I was too fast in explaining this.
Do we have other?
May I ask a question? I have no the function of raise your hands, but I am Antonia Baraggia, and I would like to ask you a question because so the principle of secularism has been considered part of the basic structure of Indian constitution. So it is a fundamental principle that cannot be amended at the constitutional level. So probably this is not, of course, the constitutional amendment, but this legislative act, of course, impinge on the principle of secularism. And so I was curious if you look at these possible grounds on which the court may decide as unconstitutional this provision, because in contrast with the basic structure doctrine.
Thank you very much. Yeah, as I said, the secularism principle was included in the 1976 in the preamble of the Indian Constitution, so it's one of the basic principles. And this law, that is of course not a constitutional amendment, is in overtly contrast with this principle. And at the moment, the Supreme Court of India has not decided yet on the constitutionality, but we can, and as many scholars have said, there is an overt contrast with the principle of secularism, even though in India, of course, has not been interpreted as, for example, in other countries. I'm thinking, for example, of France, as a complete separation of religion and the state, but has an inclusive secularism. But still, this is too much the amendment is too much in contrast with this principle. But for sure, before going to sharp conclusion, we should wait what the Indian Supreme Court will say on this. Thank you very much.
C'hai il microfono
I see a question. Yes, I see. I have a question from Professor, or remark from Professor Zeno Zenkovic.
Yeah, the only remark I wanted to make is that Francesca Raimondo's presentation confirms something that is very important. We as comparators should always keep in mind, although we live and we come from secular countries, we should always keep in mind the religious factor. I think that it would be, I hope that Alessandro Somma, who's there, can force his former colleague Enrica Martinelli that teaches religious law in Ferrara University and gave last year at the conference that Alessandro organized in Ferrara on how comparison is used by non-comparatives. What very good presentation showing how all those who work on religious law are doing all the time comparative law. And I think this is a very important. I'm just saying, I'm taking advantage of Francesca Raimondo's speech just to say that all of us as a comparative law community, we should always take in mind, even to, I mean, I'm not a believer, I'm an atheist, but if we don't want to do comparative law, we must think that this is as forms of action where religion maybe appear to be in its grace, but still commands our societies and our institutions a lot. So I think this is again a confirmation of, well, also in the previous speech by Nausica Palazzo, it showed some relationship between religion and institutions, and I think this is the confirmation of how important this is for comparative legal studies.
Yes, I completely agree. It's a recurrent topic in the international debate, especially in the field of family law, as you can easily imagine. I don't see, Vincenzo, I don't see any other question. So.
Well, if there are no, let's see, if there are no other questions, well, you can, Maria Donata, you can close the panel, but I have some information for the sort of for the community, and so you go ahead and I'll prepare. I have preparation of sort of some information I must give to everybody.
So, but my task is easy at this point. I only have to, and I have the pleasure to say thank you to all the presenters, all the panelists, and the attendees to this afternoon, to this session. Thank you for being here. It was a real pleasure to listen to you.
Pleasure. Thanks to Maria Donata. I just wanted to, if I may say, just to remind you, next week, the second week, we are having between Thursday and Friday, we have 3 webinars. The first is on Thursday, 10 o'clock Central European time, which is chaired by Maria Rosaria Marella on private comparative law. The second is on Friday, the 5th of June, always at 10 o'clock in Central European time, on comparative constitutional law, and will be chaired by Professor Violini of Milan University. And that afternoon, there will be a third webinar on Islamic and Africa at 4 o'clock in the Central European time, which makes it easier for transatlantic scholars to participate. And it's on Islamic and African law and will be chaired by Professor Lucia Scaffardi of Parma University. And before concluding, I'm just sort of, as usual, just some of you who are online yesterday saw this already, but I will just tell you that we have the proceedings of last year's conference in Parma on food and food law are about to be published. They'll be online in a couple of weeks, in a fortnight. And here you have, I'll just show you the cover of the 2 volumes. They're over 800 pages. And so just to say that you will have this online in a fortnight time. And thanks again to everybody. And well, see whoever is online next week on Thursday and Friday, but we'll be sending a reminder to everybody.
Thank you.
Bye
Bye,
to
ciao.
everyone.
And thanks a lot to Professor Kay for having joined us transatlantic, and it's
Yeah.
great.
All to my profit. Thank you.
Okay. Goodbye. Good afternoon and good morning to everyone.
Thank you to everyone.
Bye.
Bye.
Bye, Donata. Bye, Zeno.
Ciao.